I changed the title of my presentation in order to bring within the picture also my previous work. It's a very ambitious title, Labor Law for the Future of Work. Actually is even a little bit controversial because there is a kind of developing literature on the potential workless society. I mean, my argument here is that we should tackle this issue from a qualitative perspective rather than from a quantitative one. Now, the end of work is not that close, and we should rely on work that will continue to be existent. Now, I'm focusing on the topic of digital transformation of work, and I try to analyze these three key features, these three key drivers of transformation that are robotics, automation, artificial intelligence, and algorithms, and platform. Today, I'm going to focus on platforms considered as an infrastructure, as an organizational module that allows for the implementation of new rules. Now, there are a set of concomitant causes, such as deindustrialization, decausalization of labor, deflexibilization of the employment relationship. All these phenomena may be seen under the light of labor law. Labor law, according to me, is the frontier area in which transformational new realities reveal their strongest impact. So we need to assess the suitability and the adaptability of current categories in order to accommodate the new hybrid models of work and production in an effort to combine the safeguard of social rights with the unleashing of societal improvements. So, what about the definition of platform? I will rely on the Eurofunds, which is an agency of the European Union. Platform allows for the matching of demand and supply of labor. You have on one side the worker, on the other the client. Those are main logos of so many apps or platforms that many of you should know. We have different features that may be taken into account, and they imply very severe legal implication. The fact that the job is chopped up in so many tasks, the system that is based on a just-in-time, just-in-case, and pay-as-you-go model, or the fact that there is a triangular relationship between the parties. It's important to focus on this feature because there are so many legal implications. And today I'm going to present my previous work and then to focus on my project this year at the Institute. So, this was my doctoral dissertation, basically the definition, the conceptualization of an employment relationship in times of non-standard work and digital transformation. I will start from the conceptualization of the platform business model. These are the three main questions. Does platformization redefine the notion of a firm? What are the key determinants of an employment relationship? And how can we regulate platform work at the moment, at this early stage of its development? Now, in order to conceptualize the business model of a platform, I try to rely on the literature of transaction cost economics. So basically, we have these three institutional alternatives that are firms, markets, and network. In a way, a platform represents a very brilliant combination of these three traditional models because they rely on so many commercial contracts that are based on an autonomous relationship between the platform and the worker, but they are still in a position of command and control, so they may exercise a significant authoritative power towards the contracted out workforce. So all workers are outside of the domain of labor law. Again, these platforms work as network because they act as intermediaries between the two sides of a market. Now, what about the legal determinants of an employment relationship? Now, this question is crucial because the employment definition is a gateway to protection in so many jurisdictions. Outside of the definition of employment, workers are against, let's say, market forces, though they are not protected by statutory provisions. According to my analysis, the standard employment relationship, we have this distinction between non-standard, which is basically a divergence from the standard employment relationship, that is the one which is open-ended with a subordinate relationship and full-time. This is a very ideal type, which is not be that standard, but I guess it works as a point of reference. Now, the standard employment relationship is a flexible tool. There is an exchange at the basis between the protective obligation versus remuneration on the one side, and the security and stability versus the subjection to the power of the employer on the other. So this template is useful in order to facilitate innovation, and platforms such like other institutional and economic actors that takes care of innovation should rely on this model in order to foster training and the development of specific skill and so on. Now, the argument is about the flexibility of these outdated, according to someone model. What else? I try to develop this kind of case study analysis in three main subsectors of the platform economy, which are the passenger transport service, the on-demand work at the client's premises, so basically delivery, gardening, babysitting, maintenance, and so on, and the most invisible portion of this phenomenon, which is the so-called crowd work, so work completed remotely, on demand, from a global assembly line. I focused on 5 key dimensions of the relationship, from the, let's say, registration on the platform to the payment, through the assessment of the managerial power of the platform, and then the surveillance, the use of customer rating and ranking, and the possibility of rejection, for instance, of the completed project. I also try to investigate the role of European institutions. I focused on the European Commission communication on the collaborative economy, and then on the principle enshrined in the so-called European Pillar of Social Rights, and the core case, the ruling by the European Court of Justice on the nature of the service provided by Uber. So the answer are the following ones. We should try at the moment to integrate the new models into the existing legal frameworks in order to avoid the risk that platforms act as brokers of precarious work instead of innovators. At the moment, I claim that the main competitive advantage of platform is gained thanks to a partial or lack of compliance with the labor regulation, but also antitrust regulation. Now, this year, I would like to expand my project by focusing on the collective dimension of this topic. So collective social institutions are under pressure too, because of new definition, new forms of providing services, new forms of executing the employment performance. So these are the basic question of my focus here at the Institute. Does the existing legal framework, which is based on competition law, and there is a kind of clash between labor law and competition law, provide responses to these digital challenges? How can this effort lead to authentic collective agreements? And what about unions and employer organization? Will they be relevant in the future world of work? Now, we should take into account the differences. At the moment, we have many initiatives of mobilization which are happening in these subsectors. So private versus public spaces. At the moment, basically, riders and drivers are organizing sit-in, protest, and even strikes because they need interaction. We should take into account platform resistance and the terms and conditions, but also the conflicting interests and demands between these very different forms of work. The debate on the future of work at the moment is insufficiently focused on the collective dimension. We should bring this into the picture, according to me, and the idea is to update the interpretation provided by the European Court of Justice, which is based on a very strict binary divide between employment and self-employment and subordinate work versus autonomous undertaking. So the legal argument that I want to suggest here is that only autonomous workers who sell labor instead of service without an economic unity which is autonomous and they own and manage should be exempted from antitrust restriction. At the moment, an agreement between self-employed workers is seen as a cartel and therefore is deemed illicit because of the antitrust regulation. I would like also to carry out a mapping exercise of the existing and future initiatives on a OECD set of countries in order to understand the difference of means between traditional unions and new spontaneous movement. There is a clash between the dilemma resist versus the non-standard form of employment or assist them. This is the key argument. The disrupting innovation should operate in a way compliant with the public policy. Thank you.